Hello, my name is Bob Oesch. I am with the law firm of Riezman Berger in Clayton, Missouri, and this video is part of a series of videos our firm is doing to provide some fundamental information about estate planning and the estate planning process and some probate and trust principles. My name is Bob Oesch, and I am a trust and estates lawyer at Riezman Berger. I deal exclusively in the areas of estate and tax planning, business planning, and trust and estate administration. And I'm hoping that this video is informative, especially about today's topic, which is the topic of revocable trusts. We're going to talk about what a trust is, what purpose it serves. So let's get into that. A trust instrument is an agreement that one creates in order to own property and to provide for the passing of the property during one's lifetime and eventually at one's death. Trusts, there are a variety of kinds of trusts. There are irrevocable trusts, there are revocable trusts, a variety of different kinds. Today we're talking about what are often called revocable trusts. They're also frequently called a living trust. And this is a trust that one creates during their lifetime to own property. It serves similar functions to a last will and testament in that a revocable trust, a living trust, is intended to pass property at one's death to the desired beneficiaries. There are several advantages to having a trust instead of only a last will and testament. And in my practice, by far, these advantages favor most of my clients doing living trusts for their, it's a fundamental part of their estate plan. So the advantages of a revocable trust only having a last will and testament would be the following. First, assets that are owned by a revocable trust are administered easily at the time of one's death without a probate administration. This is probably the one that some people are fairly familiar with. Assets owned by a trust don't go through the probate administration process. Assets owned by a deceased person in their individual name do go through the probate process. And the probate process is an administration period or process that's involved with the probate court in the county where someone died. And while it is not the worst thing that could ever happen to one's assets, probate does entail some time and money that can be avoided by having a living trust as the owner of one's document. A living trust essentially being a dispositive document that passes one's assets at death. If one's assets are owned by the trust, then those assets owned by the trust don't go through probate. And so the delays or expenses in court fees and newspaper filings that are involved with probate are not involved with the trust. Another advantage of a living or revocable trust is the fact that the trust administration process, the process of carrying out the terms of one's living trust, is completely private. It's not a matter of public record. It's not done within the court system. No one would know about it other than the parties that are involved in the trust. That would be the second advantage. The third major advantage of using a revocable trust is one that is effective during one's lifetime, and that is the fact that if one owns assets in a living trust and one becomes incapacitated at some point in time by a disability of some kind, then a guardianship or conservatorship under Missouri law would not be required to take possession of the person's assets and then have their custody and control of the assets during the rest of one's lifetime. When assets are owned by a trust, the trust is governed by a trustee or trustees, and if a person is serving as the trustee of the trust and no longer is able to serve as a trustee due to disability or a similar reason, then the next successor, the next in line under the trust document, can fairly easily become the next trustee who's in charge of the assets and manage the assets. And again, management can be provided, care of the assets can be provided for the person's assets without the need to go into probate court and have determination of incapacity, have appointed a guardian or conservator to deal with the person's assets, and have a court-administered process dealing with that. So briefly put, a living or revocable trust is an instrument that we lawyers create for clients as part of an estate plan. It's not the entirety of the estate plan, but part of an estate plan to pass assets at one's death and also have the advantage of owning and managing them during one's lifetime. So I hope this information has been useful and informative, and you can certainly contact our law firm if we can provide more information. Thank you for listening.